Hi, welcome everyone. Hopefully you have all recovered from the marathon that is the Heckerling Conference if you were there in person attending. Thank you for joining us today. My name is Vanessa Kanega. I'm the CEO of Interactive Legal. We are just thrilled to sponsor this webinar. This is I don't know, I think maybe the fourth or fifth year that we've done this webinar, and it's always a good sort of recap and analysis of some takeaways from Heckerling. Definitely not a substitute for being there in person or virtually, but always good to have a little bit of analysis from the experts on it. So we have our experts here today, and thank you all for joining us. We have Martin Shenkman, Abigail O'Connor, and Jonathan Blattmachr, and they are going to be walking through topics of interest and giving you a little bit of color and perspective on some of the things that we all heard at Heckerling. So with that, again, thank you to our panelists, our presenters for being here. We are just so lucky and so fortunate to have you, and I will turn it over to the three of you to get us started.
Marty, are you going to control the slides?
Yes, sir.
Okay, well, please start.
We're gonna jump in. So, by the way, when Tina spoke at the end, I think she said there were over 4,000 people, all told, 1,000 virtually and 3,000 in person, which is a remarkable number. So it's certainly the place to be. I want to make a couple of my observations. Jonathan and Abby may want to comment and may well disagree, but in putting all the slides together, I was thinking about what are some of the themes or thoughts that kind of came up throughout Heckerling. And here's a few of them, and Abby and I were talking about a couple of them before we got started, sort of lamenting the complexity one. But let me just make a few comments. Dana Fitzsimmons seemingly forever has been giving a fiduciary review, which if you haven't heard him, he's an incredible speaker. His outlines are mind-blowing how in-depth and detailed and comprehensive they are. He made a comment at the end that of his presentation that he really didn't feel that there were a lot of significant new legal developments in fiduciary litigation cases that he covered. He commented that his interpretation or feeling was, and I'm apologizing if I mischaracterize his comments, but this is certainly what I heard, is that there was just a lot of mean-spirited litigation, that a lot of the litigation was just of the nature of sort of mean-spirited comments. And as a result of that, I was thinking the litigious environment, which wasn't really discussed at Heckerling this year, it just wasn't one of the topics because there's so many topics, the malpractice environment has been typified, at least in my view, by some of the same characterizations that Dana had. And I just think it's something that we need to be mindful of as practitioners, whatever discipline we're in, of the litigious nature of estate planning, of estate disputes, of client matters, and of the litigation that Dana observed. Another comment, and we're going to talk about this in detail, Abby, because I know it's got you riled up, but there are a number of cases, and we'll primarily comment, and Abby seems really kind of chomping at the bit, so I'm going to let her comment, and I know Jonathan and I have worked and spoken on it on the recent CCA, but it's broader than that. It seems to me that the IRS and the courts are really taking a look at trust modifications, whether by decanting, non-judicial modifications, maybe even trust protector actions of irrevocable trust. We had all, at least in my view, kind of gotten into this sort of new realm where, okay, it's irrevocable, but we can find, half a dozen different ways to tweak it, modify it, improve it, which I thought was a good thing, generally speaking. Now it seems like the IRS is really raising issues on that. We're going to talk about that, but that is fundamental to how many of us have started to practice. I know that Abby and I have talked about almost every client matter we've talked about has been about changing an irrevocable trust in one way or another. I think we've been reminded yet again about formalities and how critically important they are. The Connolly case on insurance buy sell was talked about, but clearly in the Connolly case, the taxpayers, as the speakers spoke about, ignored all the formalities of the taxpayers' own agreements. Sorensen was briefly talked about in prior years. Last year, Levine, the split dollar insurance case, and Smaldino. Levine was a taxpayer victory, but all these cases seem to push a theme that we really have to pay attention to the formalities of what we do. And if taxpayers don't adhere to the formalities of their own planning, there's going to be a problem. That seems to keep coming up. Abby and I were lamenting complexity. If you heard, and if you didn't, you should try to hear her. She was phenomenal. Natalie Choate spoke about the Secure Act. And my feeling after hearing her speak is, boy, I don't know that I want to give advice about this stuff. How can you possibly get your head around all the incredible complexity of that? The Corporate Transparency Act that was talked about in the recent developments, and there was a whole breakout session for, I think, an hour and a half, maybe more on it. I've done a lot of work on CTA with Abby and Jonathan, and it's still incredible how many aspects and nuances of it we hadn't addressed in all the materials that we have done. So to say that the CTA is complex is a gross understatement. And those are only two of the myriad of different things that we deal with. Basis consistency. There were a number of speakers that talked about it and how the reporting requirements are just unreasonable, violate the statute, and are hard to comprehend. Cybersecurity. You can't ignore, we can't ignore as practitioners, cybersecurity issues. No, I got somebody handling that. We're required by the ethical obligations to have some knowledge of what is going on. And to say that cybersecurity issues are complex is another understatement. Those are only a few of the very many topics that we talked about. So to say that we're really dealing with and I'm not going to say growing, I'm going to say worsening level of complexity is I think another real challenge or theme of what came out. And the final piece was uncertainty. Nobody has a clue what's going to happen in the 2024 election or what may happen to from a tax perspective. The Wyden billionaires tax was a new proposal. At the Institute, they talked about President Biden's Green Book proposals. I mean, all these things have been on the table for a long time. We don't know what might happen. We're all focused, as we need to be, on 2026, but what might happen with new legislation? What if the Sanders or Wyden type tax proposals go through and completely transform everything we know? Rev. 2023-2 was talked about, leaving a number of uncertain issues and lots of different opinions about different things. What does it take to make a trust non-grantor where a spouse is a beneficiary and you're naming an adverse party? Great uncertainty, and on and on and on. So to me, those were some of the themes or messages that may have not been explicitly talked about at Heckerling, but to me, listening and reflecting on the week of Heckerling were there. Abby, you want to comment on any general observations other than the CCA, which we'll get to?
Thank you, Marty. Yes, I have a lot to say about that one. But in general, the theme, from my perspective, and I don't think it was deliberate by any means, I just think it is what it is that we are dealing with a significant amount of complexity combined with the uncertainty. And the challenge is we have some new issues that we have not had to deal with before, and we're still figuring them out. Those who have written the rules, I don't think have fully thought them through. And so there are all these issues, and right now I'm talking about the Corporate Transparency Act and the CCA. There are numerous unanswered questions, possibly unanswerable questions. And the challenge for us as practitioners is not only do we have to try to understand it, but now we have to digest what is difficult or impossible to understand and translate that into assistance to our clients so that they can make educated decisions as to transactions and things that they've been considering. And that's frustrating for them on many levels. And so combining all of this is making our job immeasurably harder. It was a hard job to begin with, and now it's getting even harder. So that's what I took away from Heckerling. I think it was a fantastic week. And I was telling Marty before this, I really feel like I got more out of this particular Heckerling than some of the ones in the past. I think they're always terrific, but this one particularly, and perhaps that's because there is so much uncertainty going on. I think now more than ever, we all need each other, and we need these presentations so that we can talk through ideas, because we just don't know the answers to many, many questions. And I don't think anybody does. And people can guess. And it's good to hear what people guess, because they may be right. We just don't know. So that, to me, was the biggest theme of Heckerling.
Abby, before we started, you and I were chatting, and you made some comments about then trying to explain all of this to clients. Maybe just succinctly make a comment on that, because that's really important too. If we're struggling, what about the clients?
Right. I mean, I was telling Marty, as it is, my initial meetings with clients are going into 2 hours just to talk about basic estate planning, because they'll come in and they'll say, I was talking to my friends and they have a trust, and that's what we want. We want a trust. Okay, well, to talk about that, we have to start back at property interests and talk about, we have to start back at 101 before we can get to 401. And now we're adding on to this layer, Corporate Transparency Act. Clients, and I'm not talking about clients who have to have taxable estates. They can have modest wealth, but they may have, 4 or 5 rental companies, and they call and they'll say, hey, I'm about to buy a new rental. Should I put it in a new LLC? Should I put it in an LLC with others? Well, that conversation has now become more complex with the CTA, because, okay, do you want to have one more beneficial ownership report to make? Maybe it doesn't matter, since you have to make 4 of them anyway, or maybe it does matter because you want to own this through a trust and not outright, and that makes a difference. So getting the message, first of all, understanding it, and second of all, relaying it to clients in a way that they can understand and that they have the appetite for, is hard, because sometimes it's just too much. Clients come in and you're explaining it, and they don't want to get into that level of detail. They get overwhelmed, which is totally understandable. I get overwhelmed. So of course they're going to get overwhelmed. And like I said, it's just making the job harder. And at the end of the day, we're here to support our clients. And this is the end game, is to help them make informed decisions that are good for them. And this is getting harder to do.
Jonathan,
Yeah.
Other than the incredible presentation on GRATs, do you want to make any general comments on Heckerling?
Well, Marty, it's kind of hard. You guys have done a great job, but I think that once we get into it, we'll make a lot of comments which we can bring home to our audience now. So I'm not going to make this was better than that. It was a great program. I think people learned a lot. I think it challenged a lot of people. And there's a tremendous amount of uncertainty. I mean, just take the Corporate Transparency Act. We still don't know how that's going to work, or whether it's going to be extended. There's now legislation pending in Congress, which would extend the effective date effectively for another year. So you wouldn't have to turn things in by the end of this year, but you'd have until the end of 2025.
So the first session at Heckerling was a discussion of planning for modest estates, and obviously with an exemption amount of $13,610,000, even if it's cut in half, is $7.2 million. Modest is a pretty high number. I don't want to dwell on this too much because there's so much other material, but just a couple of quick comments. First, I think it's really important to review what planning for a modest estate is. And modest, apropos to all the comments we've made, doesn't mean simple, because the number of options that need to be considered are significant. One of the things they pointed out and talked about, which we're all familiar with, but just I think is important to focus on, is the impact of trust income tax planning. When you have a trust hit the maximum brackets at about $15,000 of income, and for an individual beneficiary, it could be 600,000 to 700,000 of income. There's a huge spread there that needs attention. There was some discussion of annual gifts. Just because they've been done historically doesn't mean they should continue to be done. It should really be a deliberate decision. Some clients may make just one large gift and not deal with annual gifts. Obviously, consider the compounding over time of annual gifts year after year and the growth on those gifts. It could be pretty significant. Even moderate wealth clients may make a gift in a single year to a trust instead of annual gifts. Slats certainly are a tool. Yeah.
Marty, just let me interrupt there. You and I have written an extensive couple of articles about what we call a flexible beneficiary trust, which is how to reduce the income tax when you want to use a trust. And Marty, as you and Abby know, in my view, everything needs to be transferred in trust. You can always unwind it, but that gives you the maximum opportunity for income tax reduction. So that's something that I unfortunately was not discussed in detail. And Marty, maybe we should have a program on that, the flexible beneficiary trust.
Yeah, I mean, the bottom line, as Jonathan says, given that swing in where the maximum bracket plus the NIT tax can kick in, it's a significant difference. And you need to plan ahead of time because you need to build some of those beneficiary provisions into the trust from the get-go. Another issue or point, slats are certainly something that we're all familiar with. The issue of divorce and slats was talked about, and certainly for moderate wealth clients, it's something of note. And a reminder, which we all know, but important to keep in mind, who are we usually representing? Usually it's both spouses, and you have to exercise some caution. They talk not only about, yeah.
Let me mention one thing here, Marty. On slats, my friend and colleague, Mike Graham, decided that he wanted to get more artificial intelligence with respect to slats. And as everybody knows, a slat is up there as a spousal lifetime access trust. Well, Mike kept trying to have the system learn more. This was with Chat GPT-3. And eventually it told him that a slat was a spousal living apart trust. One of the things that I found amusing and a little disappointing wasn't more on artificial intelligence. I mean, artificial intelligence is a juggernaut. You cannot exaggerate its importance, and it's happening right this minute. I mean, human knowledge doubles just about every day, and you've got to have an understanding on that, or you're really going to fall behind the change curve, and you're not going to be able to effectively practice. So that's one of the things that I think, Marty and Abby, we ought to have our own program on it, because Heckerling didn't really go into the depth about artificial intelligence, which was a little disappointing to me.
And Jonathan, on that note, ACTEC is paying very close attention to the artificial intelligence. I think there's a new task force just dedicated to that topic. If I could add one comment to the SLAT discussion.
Abby, I'm a member of that committee, and it's now a permanent committee. But again, that's for ACTEC. It wasn't for everybody at Heckerling.
I agree, and I think a seminar would be great on it. As far as the SLATs, the comment I wanted to add is this Heckerling, another theme where there was a big focus on ethics. There were 3 ethics presentations. They were all excellent. But this SLAT discussion was not an ethics presentation, but they really drove home the point of potential divorce. And most of us, in fact, I don't know of any estate planners that do not represent spouses. And I've constantly tweaking my engagement letters with spouses, and they're getting longer and longer. And I have over a page dedicated just to being spouses and being spousal clients. But this does become a tricky issue when you are you're working with clients and what to do if there's a divorce. And this is on the planning end. I think it's tricky when you're helping one client create a SLAT for the other, and knowing that divorce is possible. And I don't have an answer for you, but but there is focus on that, and it is something to pay attention to. So that was my ad.
Well, Abby, that brings up the liability issue as well. Let's say you have a couple come in, they're thinking about, we want to make some gifts to use the exemption. And you say, well, you know, you can't create these slats at the identical time with the identical terms for each other with identical assets. So let's say you convince the husband that he ought to create the trust, and then the wife leaves him, or he leaves her, or whatever. That's kind of a recipe for a disaster. Now, Abby, you know that there's a way in which you can do those trusts simultaneously and not have to worry about the reciprocal trust doctrine. And that, Abby, is known as the special
power of appointment trust. Yes, Jonathan. So we can,
yes.
There's different ways to do it. And I agree. And I think a whole day of planning can be on that. That's valid. The part that has scared me a bit is just in how to get the message across to clients. Because once you create irrevocable trust and they get divorced, now you're taking the trust and they're being handled and interpreted and argued by divorce attorneys who often I'm generalizing, often do not have a deep understanding of trust law. And as Marty said in the beginning about litigation, we're just more litigious environment. I think that we need to be very careful when talking with with clients about slats. And I'm not suggesting we go to the extent of suggesting that each client gets their own attorney, but this is something that I think needs to be thought about more in the future, especially if the clients are looking to put a significant amount of wealth into trusts. Because even as with a special power of appointment trust, as Jonathan pointed out, that still requires an actor to come in and do something in favor of the grantor.
Well,
I don't want to occupy the time.
Marty, let me just make a point that you made, which is, you create a slat for your spouse, and your lawyer was smart enough to say, well, if you get divorced, we're going to make it so either your spouse is no longer a beneficiary of the trust, because otherwise it's going to continue to be a grantor trust and tax to the grantor spouse. And you can imagine, you create this trust for your spouse and he or she winds up leaving you, or for some reason your marriage breaks down, and you're stuck with the income tax bill for the rest of your life. You will have someone who is exceptionally unhappy. So you want to change it, and that brings up, well, do you just say that if we get divorced or we separate, the spouses out, or can you safely put in the distributions will be made to my spouse or my former spouse only with the consent of an adverse party, which is what you mentioned, Marty?
One comment, then I want to move through the moderate wealth and get into the recent developments because we got so much material. And this is, by the way, exactly what Heckerling does. You can take one discussion of 45 minutes and spend days talking about it because there's so much meat there to dissect. Apropos, and I just thought of this, to the CCA we're going to come to, and I want to get Abby there because I know she's excited to talk about it. But if I have a situation where post-divorce, as part of the divorce, a spouse is going to disclaim an interest in a trust, or we divide the trust and a spouse disclaims an interest, in light of the CCA, we may now have gifts. Might we not? So it could even complicate that.
That's possible, Marty. If, for example, the children say, hey, we're perfectly okay with a modification, or if they only receive notification of it. Of course, if the kids don't consent to it, it's hard to see how they could possibly be hurt. But that's something that needs to be carefully considered.
Right. We're going to come to the CCA, but just to bring out that if you modify a trust post-divorce for a SLAT to address some of the divorce issues, you may now have a new problem. And that wasn't talked about. Paul Lee had some interesting ideas that if we have time, we're going to get to. Let me just make a few last comments to wrap up on the moderate planning for moderate wealth clients, just because there's so much more to cover. Kudos to the speakers for talking about not just the reciprocal trust doctrine, but the step transaction doctrine, because that's often lost in the sauce in the planning because everyone's so focused on reciprocal trust doctrine. But that's something that really has to be considered. All of the Smaldino case, bad fact case, but lots of good lessons about step transaction there. Upstream planning is something that makes sense. This doesn't get enough attention for lower wealth clients, but the income tax benefits can be significant and it deserves some attention. They talked about a wide range of other techniques. Just in terms of wills and revocable trust, they talked about the pros, the cons, the options of using bypass trust, Q-tip trust, Clayton Q-tip trust, disclaimers, etc. And this is sort of the one, sorry about that, the one take-home comment I want to make on that is the presentation and the materials, by giving a review of all these different options, that's kind of what we should do, not to the depth that they did with clients, not only to give clients the options to make decisions, but to protect us as practitioners. I don't think it's necessarily ideal for a practitioner. If you know that this particular client, it should be a Clayton Q-tip and that's just the best option, I think it's still good to give them some other options so they've participated in the decision process. So very good materials on doing that. Now, the recent developments, I split off a section that I called trust modification, because that was, to me, one of the themes of what we're dealing with now. The big apple in this bushel is the recent CCA. So I'm going to let Abby talk about it, and Jonathan and I may comment, and then very briefly I'm going to comment on a couple of other cases that were mentioned at Heckerling that also addressed and talked about modifications of trust. So Abby, why don't you talk about the CCA? If you want me to advance the slides, I can. If you want to ignore the slides and just talk how you want to cover it, that's fine too.
Okay, so the CCA is all about a trust modification for income tax reimbursement. So in the CCA, that particular example, there was an irrevocable trust created for the settler's child, and it was a grantor trust, and there was no provision in the trust. The trust was silent, from what we understand. The trust was silent as to any reimbursement. There was nothing in the trust saying that the trustee could reimburse the grantor for income tax. And the state law, which I actually don't even know if we know which state it was, I forget. But there was no state statute authorizing the reimbursement. There was no. I don't think the CCA mentions the state, Marty, does it? Yeah,
I didn't recall it, but we know there's no reimbursement provision in that state's law. Right. That we know. Right.
So the trust was judicially modified, and to include a new provision authorizing the trustee to reimburse the grantor for income tax generated by the trust. And the service took the position that the consent by the child, the beneficiaries, to the modification, and they said it would be the same result if they just did not object. But the lack of objection or the consent was a gift. And their reason is that without the modification, the trustee would not have the ability to distribute income in principle to the grantor for any purpose. With the modification, the trustee now would be able to distribute income in principle to the grantor, therefore depriving the beneficiary of the income and principal, and therefore the beneficiary made a gift. So this is a pretty shocking result, and is problematic for numerous reasons. One thing that is very unclear, and there was a footnote in there, and if you have not read the CCA, it's not very long. Highly recommend you read it. But there's no way to quantify the gift, and they don't answer how much is the gift or when is the gift made. I mean, is it made upon the modification? Is it made when the statute of limitations terminates or expires, this is unclear, but the amount of the gift is also unclear. You know, how do you quantify it? Because you're talking about the possibility. First of all, it's a may, it's not a shall. It's the trustee may reimburse the grantor for income taxes. But how much is that going to be? It's certainly not the whole amount of the income. It's going to be less than the income generated by the trust. But how do you determine what that's going to be, or if the trustee is going to exercise discretion? And that's unknown. So there's more unknowns created by the CCA than knowns. So that's the first problem. Is just a practical one of, okay, how many trusts are decanted to add in this provision? But then you start asking, okay, well, what if you remove a prohibition on paying income tax? Is that the same thing as adding a clause that says you can reimburse tax? But now let's extend this to other, what we would consider administrative type of provisions that allows the trustee to do something else that could possibly use income in principle for something other than the beneficiary. There's, as I said before, there's timing issues. And I think this starts to draw the question of modification in general, which is what Marty was saying in the beginning, is we've, you know, in the last 10 to 15 years, I think we've really gotten into decanting. We've started doing lots of decantings, and this came in and this seemed great and the clients loved it. And it's a way to create flexibility with irrevocable trusts, which is terrific because these trusts last a very long time now, given most states' rule against perpetuities or lack thereof. So it's nice to have flexibility. And when you're counseling clients about creating these dynasty type trusts, one of the things we say is, oh, we can build it so that it has flexibility. And we tell them about the so-called decanting statutes and that we can do this so we can create these mechanisms for flexibility. But now I think we need to be concerned, because if we're making what we consider to be an administrative modification to the trust, whether it be a judicial modification, non-judicial, or through decanting, any which way you go, or trust protector action, if we're looking at this as administrative, or even just clarifying an ambiguity, could the service take a position that the modification or the beneficiary's failure to object, does that now create a gift by the beneficiaries? And that's one big issue. The other one is, how do you get the message across? The attorney who drafts a petition to modify a trust or handles the decanting generally does not represent the beneficiaries. Usually that represents the trustee. So how do you warn these beneficiaries that they may be making a gift? It just drives a new layer of complexity onto something that I think we all have now become very comfortable doing. This is brand new. The CCA was published, I want to say December 28th or 29th. I didn't see it until the first week of January, I believe, or right before Heckerling. I think it was the first week of January. Jonathan, I forget when it came out on the ACTEC listserv. I think it was the first week in January. And it has just made huge waves, huge causes of concern, because we just don't know what it means in the long run. And we don't know, is this the basis to extend it to other types of modifications? How do you quantify the gift? What do you do? So that, Marty, Jonathan.
I have a question. Don't both of you have degrees in math?
You do.
You do. And you can't figure out how to value the gift under the CCA?
No, and in fact,
So what
Marty,
are poor non-math majors like me going to do if you two smart mathematicians can't do it?
The IRS and some other private rulings have indicated, yes, there may be a gift by somebody. We can't quantify it now. And it's refused to even provide the factors that you would consider. I mean, one of the things is, if you're going to court and the court orders it, there's a very important case that all planners should be aware of called Harris versus United States. It's a 1950 Supreme Court case. And in that case, written by Justice Douglas, I believe, the court said that if you have a local court make a change in a trust or a document, and the court has the power to say yay or nay on it, none of the people involved can be deemed to have made a gift. Now, I've used that a number of times against my friends in the National Office of the IRS who say, no, Harris is limited to its peculiar facts. It involved a divorce in New Jersey, and the court had the power to say yay or nay on the division of the assets. And yes, the court said yes to what the husband and wife had agreed to, but neither was deemed to have made a gift. Now, the law has changed dramatically on that because of Section 1041 of the Internal Revenue Code. But the court said basically, if a court orders it, then it's not a gift because you're being compelled to do whatever it is. And I'm not telling you I would take this on a low contingency, but I would take this case on a contingent fee basis. I don't see how the IRS can come in and say, Abby, Marty, whoever it happens to be, you've made a gift because you didn't fight hard enough. Suppose you oppose. The IRS once told me, okay, Jonathan, we'll respect it, but you've got to have the beneficiaries have counsel at the same level that Milbank is at. And if we really see that they fought about it and the court comes out and says X, we'll respect that. I told him it was ridiculous and I skinned the cat a different way. But this is a problematic matter and you're going to have to think about it. And one of the things you might consider doing, although it could be a pain in the patootie, is to actually have the beneficiaries file a gift tax return, make the adequate disclosure required under Reg 301.6501, and say, this happened, and I'm taking the position I didn't make a gift. And again, if the court can say yes or no, then you have no choice in the matter, whether you just lay back and take it, whether you're active and you urge the court to do it. I don't see how a taxpayer can go ahead and be charged with making a gift. That's my opinion, but I think you still have to be aware of it and do what you can to try to avoid the IRS going in. Because if they come in, it's going to be horrible anyway. You're going to have expense. You're going to have to pay a lot of money to try to resolve the issue. So avoiding the problem is the best thing of all.
I'm going to add something in, just one quick thought, because I hadn't thought of it until, Jonathan, you just mentioned this, but what if your beneficiaries are minors? They can't legally consent. They can't contract. But they can't really make a gift either. So if your beneficiary is 5 years old, and if you've got a sprinkle trust for descendants and you have grandchildren in there, you're going to have some minors, then have they made a gift? I don't think anyone can argue that a 5-year-old has made a gift of anything more than something that a coloring picture or something. I mean, it is an absurd thought to think of a minor child being deemed to have made a gift, a taxable gift in a trust.
That's an excellent point, Abby. Excellent point.
The whole concept, and I'll say quickly because you've kind of touched on it just to bring it home, the whole concept of valuing a gift under these circumstances is equivalent to how many angels can dance on the top of a pinhead. Because number one, in most of these trusts, at least that I see, you have a class of beneficiaries. So which beneficiary made a gift? Usually it's discretionary beneficiaries in the hands of an independent, often institutional trustee. So if you have 10 beneficiaries that have no vested right to a specific amount, they're just general beneficiaries in the discretion of a trustee, how much does each give? And then how do we know, and how can we possibly forecast when the trustee may decide to make a tax reimbursement payment? And most of us would advise clients using tax reimbursement clause, don't do it every year, don't do it on a regular basis. So we're already starting from the premise that it's going to be sporadic. How do we forecast that? And oh my, how do we determine what the interest rate may be? How do we determine the income of a trust? Doesn't that depend on what assets the trust owns? What if the trust does active trading? Well, we may have income on a regular basis. What if the trust is a buy and hold? What if it's a family business that's never sold? I mean, it just, the layers of uncertainty piled on top of each other make the whole calculation, I think, absurd. One of the colleagues that I spoke to said what he thinks should be done. And by the way, this is not theory. If you had a client that did a decanting or non-judicial mod in 2023, Don't you have to file a gift tax return? This is not just hypothetical. This is like, what do you do for 2023 transactions that already happened? So one colleague suggested, which I thought was kind of clever, take all these levels of uncertainty, make some kind of guesstimate of what you think the possible value of the gift is, which may be near zero, but more than a penny, put it on a gift tax return. The IRS now has to come back and tell you what the gift is. So I think the take-home point is the breadth of how far this can reach. Nobody at Heckerling could know, but they certainly expressed concern, and we've kind of reiterated that. I think we have to be mindful of this anytime we tinker with anything anymore. Very quickly, there was a Q-tip trust that was decanted to add a power of appointment to the surviving spouse, and it added through that power of appointment a $20 million bequest to charity. The IRS challenged it, saying that that couldn't be done. There was an issue over whether the level of discretion given afforded the trustee under the instrument gave them the right to decant. And in the end, the court allowed the charitable contribution because the money actually went to charity. But again, another challenge to what seemed like a fairly innocuous modification to add a power of appointment. And that's something that gets done pretty frequently. Another case in Pennsylvania, Ebersol, had similar issues about the modification of a trust. This was done to retroactively change a term of a revocable trust because it was trying to avoid a state level tax on the transfer of real estate into the trust. Again, another issue. Let's move on and get into the update recent development section. Abby, I don't think we want to, Jonathan, one of you should comment about the Corporate Transparency Act, but I think we want to keep it a little brief because we have so many other things to talk about.
So I will comment, Marty. So for all our listeners, if you don't know what the Corporate Transparency Act is, you are now far behind. And there are numerous presentations and articles available on this topic. I think Marty's website can get you to many of them. But at this point, hopefully we've all notified our clients that there is a new Corporate Transparency Act and that there is a duty for companies to file beneficial ownership reports. Again, if you are unaware of this, you're behind. Please get up to speed as quickly as possible, especially if you are assisting any clients creating a new LLC or corporate entity or anything that is any entity that is created by filing paperwork with a state or tribe. There is you need to get up to speed before you go ahead and create that entity.
And
this is a major part of, yeah.
And as Marty has as his first line, practitioners need to consider getting their own so-called FinCEN identification number. And that may save you a lot of time. So you and the client's accountants and the client himself or herself probably should get a FinCEN number. That really makes very good sense, and it will perhaps reduce the amount of reporting later on as things change.
Let me just amplify what Jonathan said. I think every flesh and blood person that could be a beneficial owner should get a FinCEN ID number, everybody, and give that to any reporting entity they have any involvement with. And reporting entities should not report the beneficial owner information, rather just the name and the FinCEN ID number. If that is done, then the entire onus of updating within 30 days of a change in data by a beneficial owner is on that owner, not on the reporting company. One of the absurd concepts here is how on earth is any reporting company going to know if Abby moved to a new address, changed her name, or her driver's license that she had used as the form of ID expired and she got a new license. It seems like it's virtually impossible for anyone to know that. But if she just gives the FinCEN ID number to any reporting entity she's involved in, the problem is solved. It's also good because now Abby's personal confidential data doesn't have to go to a company. She herself files it with FinCEN. I filed for a FinCEN ID number and it took 15 minutes. It was like truly no big deal. That will help eliminate a lot of the problems. Another two really quick points. My wild guess, and I have no basis for saying it, I think the vast majority of the 32 million entities that have to file are going to have very simple filings. Jonathan has, and I'm going to say it for him because every other lecture I've done on this with him, he's talked about a cabin he has in Alaska that's owned by him and three other guys. It's in an LLC.
Four of us. Nobody, here's the trick. You are a beneficial owner if you own 25% or more. None of us owns 25% or more. We each own 20%, and we have no officer in charge. Now, the people who made the more detailed presentation, I had breakfast with them, and they said, well, certainly all of you now have the responsibility. And I said, where does it say that? It doesn't say that, but keep in mind that not only can you face a $500 a day fine, you can actually face a 2-year jail sentence if you willfully don't report under the Corporate Transparency Act.
But I think most filings are going to be simple like that because Jonathan and his four friends, they each get a FinCEN ID number, have the LLC report once, they're done, there's no ongoing reporting. I think most will be simple. When you get to the more complex corporate structures, family offices, and the presentation, the special session on CTA at Heckerling did a great job going through a lot of the nuances of how family offices may be and private trust companies may be affected, and it far from simple. That is the portion of this that gets really complex and is going to need legal guidance. But there's a simple out, and the simple out is that you file. If you file, there's no penalty for overfiling. There's no consequence to filing. There's no cost to filing. So instead of grappling with some of these decisions, some people may just decide we're going to have people that could be beneficial owners get a FinCEN ID number and just file, and we're done. And I think a lot of the people involved may already have other entities where they have to file, so it really may not be a big burden. They may already have the FinCEN ID number. I think Abby's point is well taken. If you're not familiar with this, you haven't really dealt with it, you absolutely have to do so on an urgent basis because you have to start dealing with this now. Final point, it's not just the new entities that in 2024 have to file within 90 days, but all entities that were formed pre-2024 have to file by the end of the year, really January 1, 2025. They can't wait. So if you have a trust that has trust protectors, loan directors, swap power holders, and on and on and on, you may have a half a dozen or more people in a trust that owns a dozen different entities for clients, and all of those filings are going to have to be made. You can't wait. The clients can't wait till November to do this. No one's going to have time to deal with it. And what I think a lot of people are going to do that I've started to talk to and heard this, I just had a conversation with a client yesterday. I want to change all the different people that are appointed in the trust before the CTA filing. And we're going to see a lot of that. And now, interestingly, when you have a trust that's a dozen years old, you probably are going to want to decant it to freshen up its administrative provisions and change some of the things for CTA filing. And oh my, now you got to consider the CTA that Abby was just talking about in cleaning up the trust for the CTA. So it's complicated. Any other comments? And then we'll go on. Do either of you want to lead the charge on adequate disclosure? Schlapper case?
Well, let me mention this came out of a change in the law in 1997. And it basically said that the statute of limitations for gift tax purposes will not run at any time, not in 3 years, not in 6 years, unless you disclose it on a return to the Internal Revenue Service. Doesn't mean you filed a return for the year, but it used to be if you filed a return for the year and you innocently, even if you negligently left off a gift, the statute of limitations would run in either 3 or 6 years. But they changed the rule and they said, nope, you've got to tell us about it. Well, suppose you're in a transaction and you don't think it's a gift. What do? Well, the regulations, it's 301.6501. There's a bunch of subdivisions which basically say you've got to apprise the Internal Revenue Service of what you've done. So if you have a transaction with a family member, that's where it's going to come up. You and your son form a partnership. you and your daughter buy a business together and you don't both contribute the exact same amount and get back the exact same interest, you may well want to tell the Internal Revenue Service, look, this transaction occurred and we don't think it's a gift, but we're telling you about it. And if you make that full disclosure, and this case basically says substantial compliance is enough, but I would over disclose, as Marty said before, there's no penalty in over disclosing. Tell the service more than you need to. And the service is not in almost no case is it going to bother to look at the attachment to the gift tax return and go through it and try to figure out what's going on and then come in and audit. Because the statute of limitations, if you make the full disclosure, is going to run. And if you make the full disclosure, it's going to run in 3 years.
A couple of quick comments. We don't have the time to really get into the facts. They were pretty complicated. But the bottom line was, and the speaker said just what Jonathan did, err on the side of doing full disclosure of everything. This case is a great case to have in your back pocket if the IRS ever challenges a transaction as not having met adequate disclosure. You want, I'm going to mispronounce the case, but you want to bring out this case, Schlapfer, and use this to try to argue that you did disclose. A couple of quick comments. In the regs, there's a number of different descriptions of what has to be disclosed. And what the court said is that you have to substantially comply, not just with the reg overall, but with each of the specific sections of the reg that require disclosure. And that's why the best thing to do, which is again what was said by a couple of different speakers in different panels about this case at Heckerling, is try to disclose everything possible and just use this as a basis to argue with the service if you kind of disclosed and they feel you didn't quite meet adequate disclosure. And there was also some discussion of if you don't have a qualified appraisal by a qualified appraiser, the level of detail that has to be provided for example, a family business that you're valuing without a qualified appraiser is really daunting, and you have to be careful. But certainly a significant development, and it's a good case to know about because of some of the insights that it gives on adequate disclosure, which is something we all grapple with every year. Connolly, insurance buy sell. Jonathan, I know we had some discussions about this and didn't fully agree. Do you want to comment on Connolly?
Well, Marty, the bottom line on Connolly is we don't know where it stands because now the Supreme Court is going to hear this case. And the question is, do you have to count insurance that's paid to the entity to do a buyout of the deceased shareholder or let's say partner's estate? Is that part of the valuation of the deceased partner or the deceased shareholder's estate? And you can argue this both sides. And there are cases basically on point, and that's why the Supreme Court has granted certiorari.
The Blount case held the other way, Connolly this way, that it was included in the value. A couple of comments. I asked an insurance advisor that I work with to see if he could find out from one of the big carriers what the average dollar value, face value of an insurance buyout policy was. And the number he came back with was, I think, under $1 million or under $2 million. So one of the questions is, with an exemption that's now 13.6 and it's going to still be 7 and change if it's cut in half, a lot of the clients that this pertains to are off the radar from an estate tax perspective anyhow. They may not really care. The other thing, which and some of the speakers mentioned it, the safer way to go is not to use an insurance-funded redemption, but rather to use a cross purchase. But if you have a cross purchase and you have multiple shareholders, you may not want an LLC to own it, an insurance LLC, so that you don't have to buy multiple policies. But if you have an insurance LLC own it and the owners of the business own the insurance LLC, it's still in their estates arguably. So you really want trusts owning the insurance LLC that own the cross purchase policies. And the problem on that end, which may be the only choice, especially if the numbers get big, that's costly and complicated, and that's going to put off a lot of clients. One of the reasons the corporate insurance funded buy sell has been done is all the shareholders know what the company's doing. They can control the policies to make sure they're paid for, and it's simple, and you don't need multiple policies, and you don't need the complexity of a separate LLC. So there's some real practical implications to however this question is ever answered. Any other comments on Connolly? I have one more if you guys have nothing on the insurance aspect. Connolly, just like Smaldino and Sorensen and Levine, stressed the fact that the taxpayers had to pay attention to formalities. Connolly provided that they were going to sign a certificate of stated value or something to that effect every year. They didn't do it. Connolly provided, which many common buy-sell agreements provide, if you don't have a certificate of stated value for X period of time, you get an appraisal. And Connolly, I think, provided that they'd get 2 appraisers. They didn't do that either. The brother, who was the shareholder, co-shareholder, who ultimately got the benefit of the stock, was also the executor, and he made a deal kind of almost with himself as to what the value was. You can't ignore all the formalities and then expect the service to respect them. So that same theme keeps coming up in so many cases, but clients still seem very loath to want to let us help them with the administration of a plan. I'm sorry about that. The Cecil case. Do either of you want to talk about Cecil? If not, I can.
Cecil, Marty.
I'll tell you about Cecil. Very interesting case. We're going to do it quickly because there's so much more to come. The family business owned the Biltmore, which is supposedly one of the largest houses in the U.S. It's operated as a tourist attraction, hotels, restaurants, other activities. It sounds kind of interesting. And gifts were made, and the IRS challenged the taxpayer's value. The taxpayers used an income approach, and the IRS looked at comparable values because of the value of the real estate and the enterprise. And the court found for the taxpayer, found very large discounts as well, and agreed the approach of using income because the beneficiaries had no control over it. They couldn't realize the liquidation value. The donor, family member who was the matriarch, I forget which it was, of the family business, wanted this business to stay in the family forevermore and gave it to trusts and used a value based on income because that's what the return was to the beneficiaries. None of the individual beneficiaries could force the sale. So how can they be charged with the receiving a value of something they could never realize? And that's what the court did. There was also a discussion of tax affecting, and the court felt that you have to consider, and both experts, not just the taxpayer expert, the IRS expert, had calculated a tax effect because you can't value an S Corp the same way you'd value a C Corp without having to factor in that somebody's got to pay the income tax. Any comments, guys? Or
Yeah, let me make a couple of comments here, Marty. This case is important basically for the 2 reasons you said. If you're in a position where you cannot cause a liquidation of the enterprise, it really should be an income valuation. And there you need to look at what kind of distributions have made. It's not just the income which the entity has generated, but whether or not there's a distribution of that income out to the shareholders. Very, very important. And the other factor is that, in almost all cases, you're going to find that people are going to really have problems with minority shareholders and how they will agree on the disposition of the property. So you've got to look at, the enterprise value and not just the underlying value of the assets which the entity owns. And this is good because previously the Internal Revenue Service had taken the position we're not going to tax effect for income taxes. Mitch Gans wrote an article after the repeal of the General Utilities Doctrine, which happened in the Tax Reform Act of 1986, saying they should tax effect entities now. And because you can no longer liquidate an entity tax-free. And the IRS just fought. I've been in audits and they fight you up and down, back and forth. But the bottom line is, in the real world, a willing purchaser would definitely take into account the income tax liability. So this is a great case for taxpayers, and you need to have it, in your holster.
Assignment of income. So the donor gave stock in the Hohenscheid case to a charity. And the question is, did they give the stock and make a gift of that? Or had and this is so common in so many transactions we all see with taxpayers. There's a continuum, right? I have no deal going on. I already signed the contract and it's a done deal. How far is the client moved away from nothing's going on to we got a secure deal? And the reality is very simple. A very large majority, in my view, of clients, I don't know that I want to make that gift till I know that I'm going to really get, bought out for that kind of number, because I don't want to put all that money in the trust unless I know I'm getting bought out. So there's always this give and take about like how far can you go and still make a gift, and that's kind of what was addressed in this case. And they went too far, and it was really the anticipatory assignment of income, and the income was charged back to the donor. And they also, by the way, lost their charitable contribution deduction because apparently they didn't have a qualified charitable valuation for the donation.
Marty,
in the case,
that's an exceptionally important point. You can give something to charity free and clear. It's a great charity. You're not trying to chisel. You're not trying to cheat. But if you do not have a qualified appraisal and a qualified appraisal summary attached to your return, you get no deduction. And, my dog ate it isn't going to be accepted as an excuse by the Internal Revenue Service. It's just a provision in the Internal Revenue Code. You have to have that qualified appraisal summary attached to your return. Don't forget it.
Abby, they made the gift to the charity 2 days before the closing. You think they should have given a little longer than 2 days?
I mean, it's unclear where the line is drawn.
Correct. 2 days sounds like a little tight.
When the deal is economically certain to close, it's just compelled, it's got to happen, you're going to be in a real world of hurt. And it's horrible because you're not going to get the money, the charity is going to get the money, and yet you're going to be handed the tax bill. You do not want to be there.
This was a terrible result, unfortunately. And sorry, I was on mute before I was talking away. But yeah, if you go back and you look at the emails that were cited in this case, it seemed pretty clear the client just waited until the deal was assured, and they did try to make the argument that there were still some contingencies, but they did not appear to be of substance.
I mean, there could be a nuclear war. Alaska might, secede from the United States. Marty might have his 16th grandchild, and we'd all be celebrating that. You just can't let the client get that close to the line. There has to be a significant contingency to closing in order to take the position that you're not going to be taxed on the gain recognized.
Apropos to Abby's comment about email, John Porter gave a great presentation on tax audits, and one of his drive home points was planning for an audit is not when you get an audit notice. It's from day one when you start the planning process. And you got to be careful what goes in emails. Emails are all subject to discovery potentially. And he gave a number, I can't even remember what it was, but it was in one of the cases he was involved in, there's something like 2,000 emails that were part of it. You got to be very mindful of what's going on. And this is an issue we all face because clients doing, slats. Well, my wife and I want to do slats that are, that we can both get all the money out of. I mean, don't put that in an email. Don't even say it. Don't even think it. So good case, lots of good lessons. Jonathan, you want to make any comment about Rev Rule 2023-2, but quickly because we got so much more to try to squeeze in.
Let me mention Mitch Gans and Hugh Jacobson, who was then at Milbank, and I wrote an article in 2002 in which we took the position that although it wasn't a certainty, it looked like if you had a grantor trust, the grantor dies, and by reason of the grantor's death, grantor trust status is terminated. And even if the assets are not included in the grantor's gross estate, you nonetheless would get a stepped up basis under Section 1014. Now, people really laughed and stuff, but over the years, I've had many clients do it. I think it's very, very justifiable. I would have the client make disclosure on it, but the IRS started getting real heat from this. In particular, a congressman from New Jersey wrote to Janet Yellen, the Secretary of the Treasury, the person in charge of the Treasury and therefore the IRS, who said, these people are taking this position, we've got to slow them down. And it's very interesting. And Bernie Sanders actually turned in a bill in which he said, if the assets in the grantor trust are not in the grantor's estate, you can't get the 1014 step up in basis. And one wonders, well, if you weren't entitled to the stepped up basis, why did they come out with this proposed legislation? And why did the IRS come out with Revenue Ruling 2023-2? Let me just make a couple of points. You need to read, and it is a fascinating read. And Abby, I'm sure you and George at least once a week sit down and read Revenue Ruling 2023-2, where they
I
say,
read it to my grandkids, Jonathan.
well, I'm sure, and I'm sure they're fascinated. Can't wait till they see you again. Do please read it again. Please read it again. But basically, it says that you don't get it, but there are exceptions. For example, the ruling says this ruling does not apply if there's any indebtedness between the grantor and the trust. So if you've done an installment sale with the grantor trust and you have $1 of debt one way or the other, this ruling doesn't apply. Or if you've already paid it off, but you borrow another $1 from the trust, or you borrow $1 from the grantor, now you're not within that ruling. Now, I know it sounds crazy. How can you get a stepped up basis if it's not included in the grantor's estate? Read the September 2023 issue of the Journal of Taxation. Don't read it within 2 hours of your bedtime because you won't be able to sleep. It's so exciting. But we make very, very cogent arguments that the service shot a cannon at a problem and missed. Now, let me come to the bottom line. Let's say you've got a grantor trust out there and it's not going to be in the client's estate. You've done a great job, but the client says, well, you know, I don't get the stepped up basis. In fact, Marty, are we aware of a law firm that was sued because they did a great job, but the assets were not includable in the estate? Marty's thinking,
Was that
yes.
was that the Welling case or
No,
Rhea?
that was the one in New Jersey that you
Rhea.
were. Yep. Now, what should have happened? What you do is you go to the bank before the client dies, you borrow cash by the settlor, and the settlor buys the assets back. There's no gain because of Revenue Ruling 85-13. Now the grantor owns the asset and the trust owns cash. Even if you don't get a stepped up basis for things in the trust because they're not in the gross estate, you don't care because the basis of cash is its face amount. And then the day after the client dies, you have the client or the client's estate sell the assets back to the trust for the cash. Now, I've done this a number of times, but you don't want to run to the bank the week before the client's going to die. If you do a big transaction with a grantor trust, you want to go to the bank with your client early, say, we're going to want to borrow money before he dies. And we're going to come back every 6 months and just have a luncheon again and mention that. That way, the bank won't be upset. By the way, the money never leaves the bank. The money borrowed by the settlor stays in an account in the bank. The grantor then transfers the cash to the trust. The trust holds the cash in the bank. And then the day after the client dies, the cash comes back to the grantor, or now the grantor's estate, and the assets in the trust that were in the trust, which are now been included in the grantor's estate, get transferred back over in exchange for the cash. You will make your clients very, very happy because you would have done great estate planning and yet you will have gotten the stepped up basis. I'm a little surprised that the panel didn't spend more time talking about that technique.
We're going to jump ahead because there's so much, but this is what always happens after Heckerling. You get a couple people together as a study group or a webinar like this, and you start talking, and literally you can talk for the whole week about what was discussed at Heckerling for a week because there's just so much packed in to such a small amount of time. Just very quick comments. Paul Lee gave a fascinating presentation on partnership planning considerations. caution about, the 721 investment company rules where people are putting marketable securities into a partnership to make sure that they have either identical securities or that you plan around the mechanical test to avoid the investment company rules, which could trigger game. He talked about some concepts of eliminating discounts on partnerships by trying to create, instead of, say, a partnership, you have a general partnership, and then you have single member disregarded LLCs for each of the members and can lower the discounts. Interesting approach. I depending on the underlying asset, if it's real estate, you may still have a partition discount for marketable securities. Maybe that works. For other assets, perhaps. But again, I think the benefit of some of his comments were, more things to toss into your toolkit to deal with. Another interesting comment, and it's may not work in many cases, but it's, again, something great to have in your toolkit, is spouses created two non-reciprocal slats. And let's say, I'm going to make it simple. He used spouse one, spouse two, and I couldn't keep straight what it was. Husband had a slat with 16 million, wife had a slat that's worth 10 million. So what you want to do first is divide the husband's slat, a 6 million slat that maybe wife renounces her beneficiary status in, but you got to watch now the CCA. So now you have two 10 million slats that are identical in value. The assets are very different because they were funded with different assets that grew at different rates. You form partnerships, drop the assets into the partnership so that you end up having, if you will, an equality of identity of assets and income profiles and tax profiles for the two slats. Interesting concept. I was talking to a matrimonial attorney about it, and she's just worried that, now you're trying to get people who are having a battle in a matrimonial matter to agree on yet something else. But it's an interesting concept to keep in mind, and there may be some cases where that pulls the rabbit out of the proverbial hat, so to speak. Let's go on to estate administration. Jonathan, I know you've lectured a lot about that. What about loans? And this was Steve Akers. What about loans carrying out D&I? Any thoughts on that?
Well, there's a provision dealing with foreign trusts which say if a foreign trust makes a loan, it will carry out D&I. But it appears that there is no D&I distributed out merely because you make a low interest loan or an interest-free loan over to a beneficiary. I've done it a number of times. I've never been challenged. And I think the fact that the code says that if you have a foreign trust and you make a loan, there is the carrying out of D&I. It doesn't say that with respect to domestic trust. So I don't think it's a problem, but the service may well take the position that it is.
Didn't the Wyden tax proposal, the billionaires tax that we wrote about, didn't that have a provision that would mandate that a loan would carry out D&I?
Absolutely, Marty. I mean, the Wyden proposal, and we could spend the next hour talking about it, would be exceptionally far-reaching, the most important one of which, it would basically eliminate the use of grantor trust. And nothing would rock our world as estate planners than eliminating the grantor trust as a planning tool.
But I want to use the same comment back to you that you made about Rev Rule 2023-2. If the Wyden proposal specifically said loans shall carry out D&I, because the view there is that the uber wealthy never sell anything and pay tax, they just borrow money, right? Doesn't that also suggest on the same reasoning that it shouldn't be a problem now, because why else would he propose a law to change it?
Marty, one would think so, but we also know that the judges will come out the way they want to come out. You can't count on them being even-handed or taking a look at history. I mean, I've always felt the Supreme Court says, we never said that. Okay, we said it, but we didn't mean it. Okay, we said it, we meant it, but we've changed our mind. Why? Because we, the justices sitting now, are smarter than all of our predecessors. So even if you have a Supreme Court case on time, don't stake your children's life on it being respected another time.
Steve also spoke about the basis consistency rules 1014F and 6035 and some of the absolutely difficult, if not impossible to administer provisions. And has got some good materials on that, and I know he's spoken in great detail on that in prior lectures, and I'm going to skip through that. Alternate valuation date is something that comes up occasionally. It's certainly something to be mindful of in every probate because of the fluctuations in market values. Jonathan or Abby, do you want to make any comments on AVD? The 2053 proposals came out about a year and a half ago. By the way, the alternate valuation date, we had anti-COLA regs came out 12 years ago. Those were never finalized. And that was to prevent post-death transactions where you flip assets into, say, for example, an entity and then want to claim a discount and do that after death and then use the alternate valuation date. And the IRS said that doesn't work, but those regs have never been finalized. So similarly, the 2053 proposed regs have now been out a year and a half, and those haven't been finalized. They have present value concepts that any debt paid 3 years after death has to be discounted to present value. They raise questions about interest. They're certainly intended in part, but it's far broader to eliminate the Reagan loan concept, where you would have the estate borrow money, prepay the interest, and take a large deduction to eliminate a big chunk of the estate tax.
I thought these were pretty interesting, Marty, and something that I hadn't focused on as much before, which is again why Heckerling is so valuable. But the present value concept is, I think, noteworthy, because if you're doing some pre-post-mortem planning, which I don't know if you're planning ahead for the estate tax return, and you've got a client who might be near death, and you're sort of making those last minute, you hopefully aren't, but if you are making those last minute planning considerations, just be aware of the proposed regs. And we've known for some time that the Reagan loans were on their way out, but this was a good reminder.
And apropos to your comment, that's kind of what the regs get at. Much of the planning that we do as planners makes an estate illiquid by gifting, by restructuring, and these regs kind of attack the very planning we do, because if you created the illiquidity, then maybe you don't get an interest deduction. So how do you do the planning kind of not being 100% sure it's going to work because of this? So again, apropos to what we talked about in the beginning about increased complexity, it's all over. And uncertainty. How do you evaluate proposed regs that in 12 years for the anti-COLA regs weren't finalized, a year and a half for the 2053 regs, and on and on and on? So difficult. There was some discussion of all sorts of different interesting issues on Q-tip planning, some great reminders of things like where you can trip over discounts because of the way you divvy up assets, and some very interesting practical suggestions of perhaps funding, for example, a Q-tip with a note, putting the other assets subject to the note into the bypass trust if that's the structure under the estate plan, and then as the Q-tip pays off the note, it unwinds that. But that avoids the fractionalization of an asset potentially and the creation of a discount that could whipsaw you with a loss of marital deduction. Number of interesting issues on 2519. And this, by the way, has got to be on everybody's radar screen with 2026 around the corner, because if, as you may know, if not, under 2519, if you have the surviving spouse disclaim 1% even of the income interest in a Q-tip, then that's deemed a gift by the surviving spouse of the entire principal of the Q-tip, and then under 2044, it's not included in the estate. So it's a great way to use up dissue or exemption, and you want to use exemption, and you got to get through the dissue first, because in 2026, we all know it's going to be cut in half unless there's some change on that in Washington. I find psychologically many clients, surviving spouses, are much more comfortable making a disclaimer of the income interest in the Q-tip, because they don't kind of view that as assets the same way they view assets that have their name on it. So you may get a lot more mileage and ability to use up dissue and exemption with a Q-tip disclaimer than with other types of planning clients may be hesitant to pursue. And certainly something we need to keep on our radar screen. there were some interesting comments, and this is a situation I've seen many times, and there's some sites here that may be helpful to you. So often, especially with portability, clients want to DIY, do it themselves, not hire counsel, because Abby has a very bad habit. She actually bills for her time. And Jonathan, when he practiced, did the same thing. So we all have clients, especially on the lower end, that don't want to come in and get billed, so they're going to handle this estate on their own. That's usually a recipe for disaster. And one of the things that I've seen when they finally do show back up, they never funded the credit shelter trust because they had no idea what was going on. What do you do after the fact? And there is some discussion of doing it and maybe treating it as a constructive trust and recreating it, but you have to do something, and there's some guidance here on what to do. Not an uncommon issue. Jonathan, do you know anything about GRATs?
Well, I know a little bit. I'm with Georgiana Slade, my former Milbank partner, with Diana Zadel. We write the BNA, now the Bloomberg Tax Management Portfolio, 836 third, about GRATs and Cuperts and other things. We could go on a long time with this, but in our presentation, and if you're doing GRATs, I would urge you to get our article and read some of the things you can do to enhance the amount of mileage you'll get in using a GRAT. For example, you want to do short-term GRATs, and you want the annuity not to increase by 20% a year, but decline by probably 90% a year. And in our presentation, we talk about backup language to make sure that if the service comes in and says, you can't do that, we think you can, because your language will say it's got to work. We could spend, an hour, as Diana and I did, on these ideas, and I think they're great ideas. And if you like using GRATs, I urge you to read the article and do these for your clients. The one other thing is Attorney Berry came out with a great idea called the 99-year GRAT. I called it 100 years, and he told me I was reckless by saying 100 years, and I should stop at 99. But if you read that part, you'll see that if you have a client who's hesitant to give up property, you say, hey, put it in this GRAT. It's going to last beyond your lifetime. It's going to last for 99 years. And the client will say, gee, that's good. I'm going to get payments for 99 years yet. And yet, if the Section 7520 rate increases or the trust appreciates, you're going to have assets out of your estate without any gift tax or estate tax friction whatsoever. Super idea the attorney came up with.
Jonathan, let me ask you one quick GRAT question, because I think a lot of people misperceive the application of GRATs in today's environment. Some of the people that I've talked to say, well, golly, interest rates are so high now, and that they're high compared to what they were, but they're not high to some of the highest rates we've had. But gee, can a GRAT make sense when interest rates are now higher?
Very much so. Diana, and I think it was JP Morgan, did a study over time, whether the Section 7520 rate, which of course is the rate you use to measure the value of things in a GRAT, whether it was high or low, and they showed it didn't make a difference. The key to me is to do short-term, steeply declining annuities in GRATs, and you almost always are going to be better off. In fact, Alan Gassman has a program now. It's a wonderful thing called Estate View. And Marty, you and I have been involved with that a little bit, where you go ahead and you do a comparison over time. And Alan has shown if you just do the S&P 500, over time, you're going to remove a tremendous amount of property from your estate using GRATs.
Rolling GRATs, just keep redoing it.
Keep redoing them.
Yeah, it's the return on the asset, not the 7520 rate, that's the ultimate driver.
Absolutely. I mean, all of estate planning really is based upon investment return. Whether you're making direct gifts, whether you're doing installment sales, whether you're doing loans, whether you're doing GRATs, even if you're doing Cuperts, the key is the return on the assets involved. If that return is higher than the Section 7520 rate, and the S&P 500, if you look at any 5-year period, the S&P 500 just loses to the S&P 500 always beats the Section 7520 rate.
So another topic that was discussed was ESG, environmental, social, and governance investment standards. And there was a lot of discussion about whether or not you can do this and how you do it, and whether it's permissible or not permissible. But one of the key points that I think was an important takeaway is that this is here to stay. It's really important for a lot of clients, and it's got to be something on our radar. Because if you want a trust, for example, to pursue ESG policies, you probably want to draft for it in the trust so that it's expressed and it's clearly there as a statement of the intent of the settlor. And if it's not in the trust and the beneficiaries want it, and according to some of the studies by Northern Trust, who had one of the panelists was from Northern, a very significant number of people really do want ESG done. But then they went through a number of ethics considerations in terms of duty of care, duty of loyalty, and whether or not it's permissible. And part of what it is, and I'm just trying to find if I had it here, they talked about different types of, yes, here it is, of ESG investing. So in the original versions long ago when ESG concepts were starting, it was almost a screening process. Like, we'll invest in anything, but we will screen the investments. And if they invest in something objectionable like tobacco companies, or what's objectionable by the definition of those making the decision, we'll screen those out. And it's really evolved significantly from there. ESG integration, the duty of care is still there, duty of loyalty is still there, but you're really looking to integrate ESG into the planning. Whereas the far end of the spectrum, which is probably an issue and not permissible under the Prudent Investor Act, is concessionary ESG, where you're putting the ESG standards above investment return, and that could be a problem. But the sort of midline of impact investing may be something permissible. And Abby had indicated that, and I have the same experience, that client meetings are extending to hours to go through all of these issues. And well, now here is sorry about that, folks. Here is something else that we have to have on the agenda to talk about, because for some clients, it's quite important. And I think part of the take home was from this presentation, even if the client themselves may not be interested, their heirs of a younger generation may almost all of them be interested in this. So again, something else to discuss. So another topic, John Porter spoke about planning for audits. And one of his comments, which we said earlier, is you got to start from the beginning. It's at the planning stage that you have to prepare. He also said, which is really important, and this goes to the risk and uncertainty of what we're all dealing with, and it even becomes more problematic in light of some of the cases like in the recent CCA. He said the IRS is staffing up. A lot of the additional funding is being put into the estate and gift tax area. The number of appeals officers will be increased, and this all means one thing: more gift and estate tax audits, probably more trust income tax return audits. And I know the audit rates historically have been very low. The numbers that come to my mind, which he didn't say, but it's all changing. So I think something like only 4% of gift tax returns were audited. And Jonathan, wasn't the number close to nil on trust income tax return audits?
Well, the IRS doesn't allocate any money to the audit of fiduciary income tax returns. And as you know, I write a book with Professor Ladd Boyle on it, and we bemoan the fact that we don't get one case a year on the income taxation of estates and trusts. So if, I've told people buying a copy of my book to give as a holiday gift, as a birthday present, a graduation present, is exceptionally thoughtful. So please continue to buy it for that reason. But I don't know. The IRS in 1982 adopted an audit program. And because I wrote what I think was the leading book, I got most of those cases. I won every one. And the IRS therefore said, we're not going to audit them anymore. Now, the reason, and I'm glad you two are sitting down, and I hope the audience won't be offended. The reason that the IRS stopped auditing Forms 1041 is because the IRS is only in it for the money, and they couldn't get any money money auditing fiduciary income tax returns. Whether that will change or not, who knows? But right now, I don't think you have to worry. And the problem, of course, is that sales of our book are very, very low.
Well, according to John, we're all expecting more audits, so stay tuned. Abby?
Right. So yeah, I'd like to add in, I mean, this goes back to what one of my original comments about educating clients. And that is that hopefully when you're doing planning, or especially when you're preparing a gift tax return or estate tax return, you're making the clients aware that there's possibility of an audit. But I think now more than ever, it's important to have the conversation with your clients. And that's for two reasons. One is to prepare the client so that if they do get audited, they don't panic and they don't think automatically, well, you must have done something wrong because I got audited.
They will.
No, there's always, yeah, well, I know, but at least you're trying to prevent them. And frankly, if you're talking about a transaction with a client and you say, well, if you get audited then, and if that is enough to drive them into a panic, maybe the transaction is not a good idea. Maybe they're not a good fit. Not every client is a good fit for sophisticated planning. Just because the clients have wealth does not mean that they have to spend time, effort, and money trying to pass that wealth on to the next generation at minimal tax. It's just not a good fit for some. Some clients, their estate plan is that they're going to go spend the money and die with $1. If that's what they want to do, fine. So that's one reason to make them aware of it. And the second is just to prepare yourself and to make sure the planning is done well, and so that you are, in a sense, not justifying your fees, but if the clients understand that you are going the extra mile, you are vetting certain ideas more, you are writing memos so that if they come back and defend something, you're saying these are the non-tax reasons why we're going ahead and creating this entity, or this is why we're doing this, and you're doing this to prepare for the audit. As Marty said earlier, I bill by the hour. So the client may want to know why I had to spend 6 or 7 hours on something. I could say, well, because there's a possibility of audit. So I'm setting up the file now so that if there is an audit, we've got it in the file. If there's no audit, great. Will you have wasted the money? I don't think so, because I consider it an insurance policy. You never, you always, do you need insurance? I don't know. If you need it, you need it. And if you don't, then that's the idea of insurance. So those are the two comments I have about John Porter's. He really did an excellent presentation, but those are two of the takeaways.
Well, Abby, those were great, and I think we have to wind down. We've run out of time, and I think you're at the end. Abby, were absolutely terrific.
Can I just make one comment? I know we don't have time, but I do want to throw in a bit about
we can take a couple more minutes. It's fine. Go ahead.
Okay. So there was a presentation. It was an ethics and technology presentation on cybersecurity, and I thought it was very well done. And they started with statistics that were shocking as to how much money is lost due to fraud and all of this. But if this is something I've been paying a lot of attention to lately, one of the things that prompted me to start paying a lot more attention is that I've had a number of clients who have called me in the middle of fraud schemes when fraudsters were trying to defraud them and get all their information, and that led me to say, hey, I think, what are the scams going on out there? But this isn't about necessarily the scams. This is about cybersecurity of us as attorneys and our law firms, and having good practices. And it was a good reminder, but it always surprises me how many lawyers I still see emailing me from John Doe Esquire at yahoo.com.
Or AOL.
Or AOL.com. And, emailing sensitive documents without any kind of password protection or any other secure document delivery system. And it just goes without saying, we're doing our job, but part of our ethical obligation is to stay current on technology. And our job now includes protecting the information we receive from our clients and helping our clients protect. The presentation didn't go as far as talking about engagement letters, but Marty, I don't know about you, but I put in my engagement agreement how I hold my files. And we're a paperless practice, and we explain that to the clients and say we do our best to secure data. We can't guarantee it. I have cybersecurity insurance as part of my malpractice insurance. I guarantee you, if I have a problem, I don't think it'll be enough. I don't know that enough insurance exists out there for a breach. But they even talked about what is a breach and things of that nature. So cybersecurity should be on everybody's radar. It's your not only your ethical duty, but a good practice for your clients, and also just for your financial well-being. It could really wreak havoc.
Just like Abby said about the Corporate Transparency Act, you can't ignore this stuff anymore. And even if you're in a large firm and you have a large IT department, you still have to be somewhat conversant in it. And the example Abby said, I'm going to take a little step further. I see clients frequently emailing me from their work accounts all their confidential data. And I said to somebody yesterday, what if the family sells out to Amazon, right? They have a huge retail operation. What if Amazon or some big company buys you out? All of your personal information is going to be on the corporate computers. What if there's a lawsuit and they do discovery? Do you want your personal financial data on your corporate computers? They had never thought about it. And her personal email was a Yahoo account, just like Abby said. So what I suggested to her is hire an IT consultant, maybe use the same people that set up everything for the business, get a private domain, get all the same level of protections for cybersecurity you have at your business for your personal. You use it. She's using a Yahoo account for all her personal banking and storing all her documents on her business server, probably in the cloud, but not good. So it's not only, and they didn't speak about this, but it's just an extension of the same thoughts. When clients are not really doing things, we should really point it out to them because it's a value add. It's good advice to help them out. I think we are kind of out of time, Abby, but I think, again, and I said it during the program, is so typical of Heckerling where, you're there for this intense week. And when you start to unpack it, it just keeps expanding and expanding and expanding. Hopefully we've given you some practical, great insights. Hopefully we've given you, some useful themes that we each saw at Heckerling, and sort of a high-level overview of some of the highlights from many of the different programs. And I'm thrilled that we made it to slide 109. So I think we covered a lot of ground. Abby, any final remarks or comments, and then we'll see if Teresa's here to say goodbye.
Thank you, Marty, for including me in this wrap up. But I do encourage everyone listening to attend Heckerling. If you don't want to travel, they do it virtually now. I would think this is permanent, where they allow you to attend virtually or in person. So if you don't want to make the trip, that's fine. There's another way to do it, but it's a week. It's exhausting. It's drinking from a fire hose. And
are you talking about the mosh pit at the bar?
Marty, you attended virtually this year, so you weren't there. You didn't see me there. But I think it really is worth it. It's an investment of time. I mean, it's great to listen to these wrap ups, and we're happy to do them. But there's no way we can cover 1 week of the in-depth knowledge that you gain from Heckerling in really any kind of a summary. So I do encourage you to attend, and then use these types of seminars as more of a review. And Marty, you said study group. I love that idea. I mean, I feel like this is basically a study group for you and Jonathan and me.
By the way, just comment, if you can physically go to Heckerling, and some of us can't because of health issues, there's no substitute for physically being there. You can virtually, as I did this year, attend the courses virtually and get just as much out of the courses as somebody sitting there. But what you can't get are two things. One, simply walking through the exhibit hall educates you and informs you of what's going on in our profession. And it's fascinating to me to see how over the years it's evolved from mostly like banks and financial institutions and accounting firms to tech. So much of it is just tech oriented now. And just walking through there helps you see what's going on, what's on the cutting edge, and where you want to think about taking your practice. And the second piece of being there physically, there is nothing in our entire profession that can remotely compare to the networking opportunity of being at Heckerling. You can have meetings, breakfast, lunch, cocktail hour, dinner, after dinner drinks, and maybe even at a happy hour after that with different people. You can meet 20, 30, 40 people, like meetings, in 1 week. You can't do that anywhere. So it truly is a remarkable experience. I'm not sure if Teresa is still there. Oh, Vanessa.
Yes, Teresa is
You
not
stayed
here,
awake.
but I'm always. No, I did. I'm always second best to Teresa, but I'm happy to give the wrap up. I just wanted to say truly thank you to you both, and to Jonathan, who had to drop off, for doing this. It takes an inordinate amount of time to prepare these materials and summarize everything so nicely. So thank you very much for doing that. And for everybody attending, thank you. And we do have many more webinars presented, some of them presented by this panel, on our website at interactivelegal.com. You'll also find them, I think, on on Marty's website at Shenkman.com, some additional webinars. So,
and Vanessa, you're going to post the PowerPoint too for everybody.
Yes, we post the materials as well, yeah, along with the webinar. So you'll be able to access it on our site if you want the recording. I think if you're attending, you will automatically get the recording as well. So thank you both for all your hard work on this, and thank you to everyone for attending. And we'll see you all, I'm sure, again next year for the same topic.
Take care.
Thank you. Bye.